Subject to recall?
Yes.
Okay, sir, since you're subject to recall, you cannot discuss your testimony with anybody. You do not need to stay here today, but just be on call for that, okay? And you're still subject to the rule of witnesses, okay?
Yes, Your Honor.
All right, thank you. All right, your next witness?
Harry Litzky.
Do you swear or affirm to testify truthfully in this case under penalty of law?
I do.
Thank you.
Sir, can you please state your name and spell it for the court reporter?
Harry Litzky, Harry, LID as in David, SKY.
And how are you currently employed?
I'm currently a private investigator and digital forensic examiner, self-employed at my company, 4DIS.
Okay. And what's your background in terms of digital investigations and investigations?
Prior to starting my own company, 4DIS, I retired after 20 years in federal law enforcement, 7 years with the DEA, the Drug Enforcement Administration, the remaining 13 years with the U.S. Department of Justice, Office of the Inspector General. For the last 11 of those 13, I was in the Cyber Investigations Office, where I progressed as a senior special agent to the assistant special agent in charge and retired as the special agent in charge of that office. The Cyber Investigations Office handles, as the name would imply, digital forensic examinations. We're responsible for supporting the entire agency nationwide with mobile and computer forensics, basically anything with an on-off button, anything that was electronic in nature, is where we came, our services were brought to bear. On top of that, we ran our own investigations, those specifically which were digital forensics centric.
And in terms of issues, have you ever heard of catfishing?
Yes, I have.
Have you worked within investigations where it's alleged or it's found to be catfishing?
Yes, I have.
So do you understand the elements necessary for catfishing?
I do.
Describe for the ladies and gentlemen of the jury what that exactly is.
It's a form of misattribution in terms of who's performing what activities. So at its core, it's somebody pretending to be somebody else, usually designed to lure somebody else to do something. It can be employed in a scheme to defraud. It can be employed to get somebody to show up, to get them in trouble, to get somebody to show up to an event they had not intended to show up at, to misdirect somebody to show up for something. A case that I worked, it was employed to misdirect somebody to show up who thought they were coming for a consensual sexual encounter, not unlike this particular case. And in fact, they were there to serve a different purpose, to be set up as a victim, as a utility or a tool in that particular investigation.
So in that particular investigation, was that from the prosecution side or the defense side?
That's when I was a criminal investigator, a federal agent for the Department of Justice.
Okay. Now, in terms of your investigative experience, even beyond digital forensics, can you tell the ladies and gentlemen of the jury what kind of experience and what kind of responsibility you had while being a federal investigator?
Well, in addition to the digital forensics, again, 7 years with the DEA, it was drug law enforcement. Pretty straightforward. What you'd think, what you'd expect, I guess, between the street level version of it, domestically, always working our way up towards the source, back to the cartel sources, and usually overseas. But through that, I gained experience with interviewing witnesses, interrogation of subjects, obviously arrest tactics and things along those lines. But there was also a strong money laundering component involved with that. There was surveillance skills were heavily employed during my time with DEA. I did a lot of undercover work with DEA. At the DOJ OIG, the Department of Justice's Office, the Inspector General, we were the watchdog for the Department of Justice. So we investigated both administrative and criminal waste, fraud, and abuse type misconduct that occurred within the Department of Justice, that is, employees of the Department of Justice, or also from external actors affecting the business of the Department of Justice. And through that, we did a fair amount of investigations, to the extent that makes sense. There was a number of high-profile investigations. Fast and Furious might be one of those, where our investigation was aimed at the investigation or the operation conducted by the ATF in that particular instance. And we would often find, we would make assessments, recommendations, and even punishment recommendations for employees that acted either out of malice, ignored or abused policy, whether they engaged in misconduct inadvertently or maliciously. Those were the type of findings we would have. So if we found that an investigator failed to adhere to policy, we might have a finding. If we find an investigator lied to us, or in an investigation, somebody within within the purview lied to us, we would find they lacked candor. So we, our reports, our investigations resulted in terminations of employees. Sometimes they were.
Judge, at this point in time, I think we've launched into a narrative that is not responsive to the question, nor is it relevant.
All right, if you want to ask the next question.
Well,
Continue on that.
it was a question about your investigative background, so please continue.
Yeah, so that was the gist of what we did. So it's pretty broad spectrum of investigative experience. That added component from the OIG of having the investigative oversight and being the watchdog to include over investigations and other police officers, other federal agents, other prosecutors, was a nuanced twist, I suppose, in my experience there. In addition, there was the more traditional, straightforward investigations we conducted to include everything from white-collar, bribery, catfishing, international money laundering, conspiracies, and the normal type of white-collar crime.
And in terms of your investigating the investigation, you were actually dealing with law enforcement people who came.
Objection leading.
All right.
Explain what you did in terms of the investigation of the investigations.
Sure. DOJ is huge, the biggest law firm in the world, as we like to say. DOJ includes the FBI, the DEA, the ATF, U.S. Marshal Service, Bureau of Prisons, U.S. Attorney's Offices, Interpol, and about 40 other smaller components, tax division, civil rights division. So we were a massive agency far and wide. So we were made up of federal agents, FBI, DEA, ATF, and the Marshals. But we were also made up of attorneys. We were made up of auditors. We were made up of all sorts of employees. We had IT employees engaged in inappropriate network activity where they were reading other employees' emails improperly and illegally. So whenever somebody was accused of misconduct, whenever an allegation of misconduct came our way, we would take that on. So it can take all forms.
Now, going back to the digital forensics investigations, you indicated you were there for 11 years?
Yes, sir.
Okay. And during that period of time, were you ever qualified as an expert in the court of law?
Yes, I have been.
Okay. How many times?
I say 3 or 4 at the federal level, and once since retirement here in the Commonwealth.
Okay. Your Honor, I'd move Mr. Litzky in as an expert in the fields of digital forensics and general investigation.
All right.
Judge, I'm not familiar with general investigation as an expert field, but certainly digital forensics we would accept.
I'll move him in as for digital forensics expert.
Yes.
Okay.
Sir, you became involved with the Banfield case. What was the first thing that you did when you started reviewing evidence?
The first part of my evidentiary review focused on the digital forensics. I was provided with a rather large Volume-wise, hard drive, 8 terabytes, I believe.
And the digital forensics, and I guess, Your Honor, I would just state that the digital forensics that are the foundation have all been stipulated to in the stipulation document in terms of
In terms of a report or digital,
in terms of the data that was taken from the devices.
Yes, Your Honor, we have
Okay.
stipulated that the raw
data.
data pulled from the devices does not need to have a chain of custody or
okay, right,
foundation.
so he can talk about the raw data from the
Correct.
devices. Okay.
Yes. And so, sir, what's the first step in your analysis of digital forensics when you get involved in the case?
Well, in this particular case, it was atypical because I didn't have to perform any of the acquisition phase of it. Detective Miller had already performed all of the digital forensic acquisition. So what I was provided was generally the derivative elements of his work, which allowed me to just jump right in and review the various artifacts. When I'm performing a digital forensic exam that's derivative of somebody else's work, I make it a point not to review their findings. The reason being, digital forensics is somewhat analogous to solving a big math problem. So to perform it accurately, or at least the way I like to perform it accurately, I like to do the work myself, see what answer I come up with before I see the answers of somebody else's work. Digital forensics is a science such that we're all trained similarly. We all take the same training. We all operate the same way. If we perform our actions as we should under the guise of best practices, we should do the same thing, each one of us, and come up with the same results. Digital forensics is repeatable. Digital forensics, it should be, it's binary. The data is the data. It's not subject to interpretation. It's not subjective. So what you see is what you get. There are nuances in understanding it and what it means. Assigning attribution is a different phase of it, but and we'll eventually get past this boring stuff and see some of it. It does reveal what's going on behind the screen, typically on either a phone or a computer.
Now, in terms of the digital forensics in this case, how do you arrive at certain conclusions?
So, digital forensics, like most of the forensics, and we've heard a fair amount here so far in this trial, it's supportive. It can be informative. You can draw certain conclusions, but they're based upon the results of the digital forensic analysis and its impact on other items of evidence or other items of investigative nature. And what I mean by that is, for example, if somebody says, if we're investigating a crime that took place in Boston, and somebody says, I have an alibi, I was in Miami, and I look at their phone and there are artifacts that reveal location information in Miami, that is an informative piece that says this individual, based on their phone, might have been in Miami at the time. Now, phones can travel without, are traveling with them. So was the phone there? Was the person there with the phone? So that's a lead, that's a pointer. The follow-up to that would be, okay, do we have airline records? Do we have video surveillance from an airport? Do we have video surveillance from a hotel in Miami? Do we have credit card transactions from a restaurant in Miami? Other indicia of location. So digital forensics is informative. I guess if there's enough digital forensic pointers that can, I think pass a test, then it can be conclusory as well, and we can draw conclusions from it.
And in your example of something in Miami, when you arrive at a certain number of artifacts that say the person's in Miami, is that it?
It can be. That's probably a bad example in terms of being conclusory. If somebody says, there's no pictures of a red sports car on my phone, and I find 100 pictures of Ferraris that are red, that's conclusory to say that the witness information or the interview subject information that they provided to the investigator, whether it was me or somebody else, is clearly wrong. Now, that doesn't get to whether they misremembered, whether those photos are old, whether they were taken by somebody else. So there's still an attribution aspect, but it can be conclusory or informative in that regard.
Okay. Now, in the context of this case, what were you trying to determine based upon the theory of the Commonwealth in this case?
So this case, I've the luxury of coming in at, after the things had developed. The theory had already been assigned. Catfishing was already, Mr. Banfield had been charged already and indicted under a catfishing theory when I was brought in. So that was my immediate focus. So confirm or refute that theory. As an investigator, whether I'm in my law enforcement capacity or now in my private capacity, the facts don't change. The facts are the facts. Facts don't take sides. The truth doesn't take a side. So for me, just because I'm hired or asked to investigate one particular theory, it doesn't mean...
Judge, I would object at this time. This is non-responsive.
All right, I'll sustain as non-responsive.
Okay.
You want to ask your question?
Sir, in terms of what you did when you started this investigation into Christine Banfield's devices, what did you do?
So I started evaluating the devices, but at the same time, I reviewed other evidence that was available to me provided in the discovery. That would include witness interviews. That would include subject or co-defendant interviews. That would include social media type event like email, Instagram, Facebook, things of that, WhatsApp. So it's not all a device centric. It can be evidence provided by a service provider like Google or Apple. I reviewed all the photos from the crime scenes, the autopsies, the digital, the forensic science and Office of Medical Examiner. I reviewed all of the facts available to me. The best way to perform what I do is through all source
Judge,
analysis.
objection, non-responsive.
I sustain the objection.
Okay.
Just answer the question.
So in terms of the items that you were just telling the jury that you review, did there come a time where you were reviewing and were able to arrive at conclusions?
Yes, I was.
Okay. And specifically, what date range or what period of time were you looking at?
So the window of time was from January 9th, 2023, specifically with regard to the catfishing, was from January 9th, 2023, obviously through the time of the event on February 24th, 2023. It did extend back a little bit further. For example, the discussion about the windows, that dated back prior to January 9th. There was witness testimony or subject interview, transcript information about planning that predated January 9th. So I don't just look at a time for digital forensics. It's important to look backwards for a certain relevant period to ensure that
Objection, non-responsive.
Sustain the objection.
Why would you look backward in a digital forensic analysis?
a single artifact, as we refer to them in digital forensics, is it may not be informative, right? A single text message on this day may lack the context, but the 50 prior exchanges might help that context, right? That's relatable, and the communication after that might also help inform. So it's important to look backwards. It's also important to look forwards in digital forensics. And when we're talking about, in this case, the allegation of a conspiracy that lasted a period of months, I find from an investigative perspective that it's important to look at everything. Digital forensics, like any, I think, informative piece of evidence, should...
Objection, non-responsive.
Sustain the
In
objection.
the context of certain behaviors that come up through the investigative process, like, for example, when someone may have had their phone and their laptop and when someone would have been away from that, are those things that you look at?
Especially for events like that, what was happening immediately before the event is vital in determining attribution or who might have been performing what activity on a device.
Or saying in another way, would there be,
Objection leading.
I haven't heard the question yet.
what would you do if there was a pattern of time that needed to be analyzed, or a time of day, or a certain day? How would you go about doing that?
Well, with the digital forensic tools that we have, the software that we have, we're able to visualize things in a timeline fashion. So I'm able to look at, or folks in my profession are able to look at what happened, both what the user was doing and what the system was registering, the computer system. So we're able to generally create a granular timeline that helps inform a decision or conclusion about whether a device might have been removed, from one person and used by another.
Okay, now can you see the document that's on your screen?
I see Detective Miller's executive summary.
Yes.
Yes,
Have you had an opportunity to review that?
I have.
Your Honor, can that be published to the jury?
It was not admitted into evidence.
Okay, I'd move it into evidence. as
Objection,
Exhibit
Judge, it's a
85.
hearsay document at this time.
I'll sustain the objection at this time.
Detective Miller testified to it.
If you want to approach. So I'll sustain the objection.
Mr. Litzky, I'm going to go to, sorry. Can you see something on your screen there, sir?
I can.
Okay. There's evidence in this case regarding window replacement that was communicated by Juliana Perez Magalhaes. Do you remember that?
I do.
Did you do a digital examination? Did you do a digital examination as to the allegations that she made with regard to window replacement?
I performed searches relating to that particular topic. I'm able to perform keyword searches as one of the search criteria. So I did perform searches related to that particular part of testimony, yes.
Okay, and was this part of the information that you'd received from our discovery and the data that came from the devices?
Yes, it is.
Okay. I'm going to have you look at the document that's on your screen. Can you, Your Honor, I'd identify this as Exhibit 86.
All right.
Can you look at Defense Exhibit 86 and explain what we're looking at here?
Judge, I'm going to object to any statements regarding what's contained in the document.
Are you moving it into evidence, Mr. Carroll?
Yes, Your Honor.
Any objection?
Yes, I would object to foundation. We have not been given any information about this
Sustain as
document.
to foundation, if you want to lay a foundation.
Sir, how did you find these documents, and what processes did you use in order to find this information?
So based on the derivative evidence provided to me in discovery on this case, I analyzed this particular one. This came from Miss Banfield's cell phone.
Judge, I'm going to object to that conclusion. Again, there's been no foundation laid, and we can approach, and I can explain further.
Or you want to approach?
Sir, what was the raw data that you used in order to get this, and what system did you use to arrive at this?
This was from an Axiom portable case created by Detective Miller. An Axiom portable case is a derivative product from Magnet Axiom for digital forensic software, which performs mobile and computer device review, or facilitates mobile and computer device review and cloud review and all things digital. So the software is baked in. It's an executable program that comes from the main Magnet program. So Magnet permits digital forensic examiners, in this case Detective Miller, to create a derivative subset of his work that is able to be open on any Windows computer. So you don't need to have a software platform. It is a software platform.
And if you can tell the ladies and gentlemen of the juror, or Your Honor, we move that in as comes, or defense
Same objection.
If we
exhibit.
could approach, please. All right, so the objection is sustained.
Sir, did you work with the raw data that was provided by the Fairfax County Police through search warrants and other providers, things like that?
For search provider, for service providers, yes. The records I had were responsive from Google, Apple, Facebook, and Instagram, FetLife, and others, Discord. For the computer and mobile devices, I was not provided the raw data. I was provided the derivative work, the portable cases, the Celebrate readers, which to my understanding is the complete device. Nothing is filtered out, but I wouldn't characterize it as raw data.
Your Honor, may I just request a 10-minute recess?
We want to do our afternoon recess? We can do that?
Yes.
Okay, let's go ahead and take our afternoon recess for 15 minutes, ladies and gentlemen. And we will get right back to you. Again, don't do any outside research and don't talk to anybody, okay?
Yeah? Correct.
All right. Sir, since you are in the middle of your testimony, you can't discuss your testimony with anybody to include the defense at this point, okay?
Of course, thank you.
All right, we'll be back at 3:15. All rise, please. All right, we ready for the jury?
Yes, ma'am?
Okay. All right. C, your next question?
Judge, I don't have any further questions for Mr. Litzky.
All right.
I would ask to recall him at a later time.
Okay, well, cross-examination?
Not at this time, Your Honor, no, thank you.
Okay, all right. Sir, since you are subject to recall, do not discuss your testimony with anybody, and you may be recalled, okay? But you can have a seat. Thank you.
Can I call Detective Miller?
Detective Miller? Again? He was just sworn.